Hey everyone, this is Eddie, and welcome to this review of the performance test of the California bar exam that was administered in July of 2017. And what do we have here? We have a client, our client, Blake Davis, and he has been charged with a misdemeanor and with a felony. And the good thing is that the U.S. Attorney's Office is willing to consider a plea bargain. So what we want them to do is for them to accept a guilty plea to the misdemeanor charge and to drop the felony charge. And if they do not do that, and then we are going to move for a motion to suppress because the drugs were obtained illegally in violation of the Fourth Amendment, which protects against unreasonable searches and seizures. So let's go into the discussion. And we already talked a bit about Fourth Amendment. And of course, to conduct a search, that requires a search warrant. That does not exist here. However, there are exceptions to the search warrant, and one of those applies at the nation's borders or to its functional equivalent. And here we have two types of border searches. We have the routine search and we have the non-routine search. And here in the facts, it was established that the search was conducted by the United States Customs and Border Protection Service, or the CBP. Let's first talk about the routine searches. Do we have a routine search? What is that anyway? A routine border search may be conducted with no probable cause, nor with reasonable suspicion of wrongdoing. However, to search a private sleeping cabin, reasonable suspicion must be present. Is there a case law on point on this matter? There seems to be no argument that a search of a ship's hallways is routine in nature. So what is the government going to argue against our client? They're going to say that if a drug sniffing dog signals an alert, then that amounts to reasonable suspicion of criminal conduct. And of course, that's the case, United States versus Braun. Now, our task is to show that the government has a weak position against our client. And we're going to say that United States versus Braun is a Florida case, and it is non-binding in this jurisdiction. Furthermore, Braun is a trial case whose opinion on the drug sniffing dogs was based on dicta. What does that mean? It means that the use of trained canines to establish reasonable suspicion has not been litigated as a central issue. And that's great for our client. And in this jurisdiction, a court may rule in favor of Mr. Davis on this matter. Now, I do want to make a side note there. The dicta argument was not apparent, so if you caught it, I believe you will receive extra points. Now let's talk about non-routine searches. What is that? A search of a cabin of a passenger on a ship requires reasonable suspicion of criminal conduct based on specific and articulable facts. And here there was a non-routine search because Mr. Davis's cabin was specifically targeted and was searched without a warrant. So next, it must be determined whether reasonable suspicion was present. Let's talk about that now. So here we have already discussed the issue of the use of trained canines to conduct a search, and we concluded that our client has a strong defense there. Now, can reasonable suspicion be established by other means at the time of the search? Let's look at the reasonable suspicion standard that was relevant here. And we have some elements. Let's go through these individually. Number one, the information is known to the government agent. Number two, that includes information that was obtained by an informant's tip. And number three, where a drug-related arrest and seizure of drugs was made. So that comes from the case United States versus Clark. Let's go through the facts here and see if they match up. And here, these elements are simply not found against Mr. Davis. Thus, reasonable suspicion to search his cabin did not exist. However, could these elements be found against another passenger? Let's look at the facts. Let's go through the first fact. So here there was information known to the government's agent that was accessed through the Treasury Enforcement Communication System, the TECS computer database. So that first element is met. Number 2, we also have an informant's tip stating that he observed a person in the company of suspected drug dealers. And that information was filed by an undercover CBP officer stationed in Acapulco. And number 3, there exists criminal records showing that a conviction for possession of heroin and sale was present. So it does seem as if those elements were met. Now, here's where you come in as a strong advocate for the client. However, that information did not relate to Mr. Davis. The CBP was targeting a different person by the name of Davis, but with an extra S. And of course, we will discuss that in much detail later. Now, it must be determined whether that mistake of the government was equivalent to non-reasonable suspicion. Let's turn to that discussion now. Non-reasonable suspicion arises when suspicion comes from mistakes that are themselves unreasonable. Again, that comes from U.S. versus Clark. Here, it must be shown that the mistake by the government amounted to non-reasonable suspicion. And again, here's where you step up to the plate and make strong arguments in support of the client. And you're going to use facts that are found in the case, and you have quite a few factors there. Let's go through them. The extra S in the Davis matter, there were many facts there. Also, the CBP never asked for Mr. Davis's passport until after Mr. Davis was arrested. And moreover, when the CBP examined Mr. Davis's passport, the officer became aware and admitted that there had been a mistake. And also you have the physical differences in height, weight, and age. And also there's the reading of the passenger crew manifest from the TECS. And there you had rooms that were on the same deck, but it had different room numbers. So overall conclusion, for the reasons stated above, we ask you to charge Mr. Davis with a misdemeanor and to drop the felony charge. So we hope to hear from you soon. And that concludes the review. I hope this helped. I hope you passed. Until soon.